Thank you.
Yeah, so today we're going to learn a little bit about estate planning, the financials, and a little bit more about what it takes about the financials of a brain injury. So Mr. Miles, our guest speaker, began his career working exclusively within the taxation field. Originally, while in New York, he worked in the accounting firms of Edward Isaac & Co., as well as PwC. He later moved on to Global Tax Department at Merrill Lynch. In 2004, he went to Georgia and worked in the tax department of Singular/AT&T. He began his law firm in March 2008. And then in 2009, his first wife passed away from cancer. That experience caused an expansion of his law practice to focus to incorporate estate planning. Over the years, he added elder law to his practice to assist individuals and families to prepare for long-term care and special needs planning. Mr. Miles is a member of the Estate Planning Council of North Georgia. He's also a member of the Georgia and North Carolina chapters of the National Academy of Elder Law Attorneys. We're really pleased and honored to have him and speak in front of you today, and we would like to really thank him for his time and his support today. Thank you.
Thank you, Justin. I appreciate that introduction. And thank you all for having me. It's an honor for me to be here. As always, happy to speak about this topic. And I really am excited. This is something I'm going to make sure I can share this. So tell me if you can see this or not. And, all right, so I'm going to start this. So as Justin said, we're here to talk about estate planning. And when I talk with the leaders of the group, we kind of decided to break this up into two pieces. So the first session is tonight, and this session is really the key elements that pretty much every single family should have in place. And I'm gonna try to emphasize tonight that this is really not something that is income level dependent. And I know in my field, when people hear estate planning, they think of one of two things. They think of death, of course, right? Because this figures end of life stuff. And I try to counteract that because you'll see as we go through, a lot of what I do and what a lot of estate planning attorneys do is focus on issues that happen while you're still alive. So we try to focus on quality of life issues. And then also people think of money. They think, well, I don't have enough property to really worry about doing estate planning. And I'm also going to go through some of the issues that we encounter. And hopefully as we go through, you'll see that money and the amount of money you have is not necessarily going to come into play in a lot of these situations. And the next month, that's when we'll do the particular focus where we start getting a little bit more into special needs trusts, government benefits, guardianships, conservatorships. So definitely wanted to break that up because it's a lot to try to take on in one session. So Roger, we mentioned that maybe you have the caregivers come next time and it'll help to have them think about their own estate planning, especially trying to leave assets to their loved one and what's the best way to do that. So we'll look forward to that next time. So I try to always start and say, well, what documents are in practically every standard estate plan? So if some of these are new documents here, I'll kind of give a brief background on them. Power of attorney, that's the financial document. That's the document where people need someone to handle their bank accounts, investments, insurance, anything that a lot of times is property related, real estate. Advance directive and HIPAA authorizations. These are the healthcare decision forms. So the classic, if I'm in a vegetative state, do I have my life extended? That kind of form. Or if you just have a situation where you might not be able to make a decision and you want to appoint an agent for you. Beneficiary designations, those are things like your 401k, your IRA, your life insurance. Those things are going to pass by the form, by the contract. So even if you have a will in place when you pass, your will won't affect a lot of these documents. So it's important to know what passes by beneficiary designation versus what will pass by the will. So a lot of times when we meet with someone for their first time, we'll do a questionnaire and try to get their assets. And a lot of times people are resistant on, I guess because they're very private, they're not trusting yet of giving that information out. And we have to explain to them, we need to know how you own, not only what you own, but how you own it, because that's going to dictate to us how we need to proceed and determine whether or not certain assets will automatically pass or whether they will need to be forced to pass by a certain method. If some of you might have heard of a revocable living trust, a lot of time that's marketed to avoid probate. Probate is when someone passes away and you have to take either the will to court, or if they don't have a will, you have to go down to court and get some letters, some permission, what we call power of attorney letters, letters of administration, to try to handle their estate. So to avoid all that, many times we try to create a living trust, and the living trust will avoid having to go to court. It also works during life, so that if you put your assets in the revocable trust while you're alive, and say for some reason you're incapacitated, say you get Alzheimer's at some point, you can write in who's the next person to be the trustee, and then you never have to worry about handling your property while you're still alive. And then, of course, the classic will, that document that takes place after you pass away. It handles distribution of your assets, but the important part is it also handles appointing a guardian for minor children. So we'll go through the examples and see how that happens. Okay, so here's some examples of the document. First one, how do these documents work? So medical professionals and your family do not have to guess whether you want life-extending measures taken if you're in a vegetative state or end stage of a terminal illness. And that would be the advance directive. We've all heard those tales and those famous things where families are fighting whether someone should be kept alive or not. That is definitely a situation where you want to have your documents in place to express your wishes. So my family can pay bills or other expenses by having access to my bank and or investment accounts. Regardless of how much money we have, if something happens to us, bills need to be still need to be paid, the utilities, your mortgage, your car payments. Someone needs to have access to your bank accounts. So that's going to be the power of attorney document. My family does not have to seek court permission to handle my legal, financial, medical affairs if I become incapacitated. A lot of times, people don't have the chance to do these documents. So if it comes to that point where, say, those bills need to be paid every month, if you haven't done those documents, you're not in a position sometimes mentally to complete them. So then the family has to go to court and then go through a procedure to get the papers appointed, and then they usually have to have court supervision, so it becomes very expensive and also very emotional and time consuming. So we want to try to avoid that. Speaking with doctors or accessing medical records, that's a HIPAA form. Many times people think automatically because they're in a certain relationship to someone that they can walk into the hospital and get information on the person that they care about. But depending on the circumstances, sometimes people come, oh, well, they think they're the mother or father, and they walk in and say, that's my son or daughter, but they may not get information from the doctors, especially that son or daughter is an adult. They still have protected information, so they're not going to assume that it's okay to give out their medical information. So you always want to make sure you have those forms in place. You have guardians and conservators appointed for minor children. This is a big one. Anyone with minor children, if something happens to you, of course, you're emotionally concerned about what happens to them, but literally, you have the opportunity in a will, and the will is the only place you can do it, to appoint a guardian or conservator for them. Guardian is over the person, guardian is over the child to determine where the child lives, and conservator is handling the money. Sometimes you want to separate those roles, because we all know some people that might be very good people, but they may not be good with money. So sometimes you make the same person serve both roles. Sometimes you want to split those roles among different people. The only way to do that is in a will. So my spouse children get my estate instead of my creditors. Many times when I mention probate, when you pass away and go to court, that's an opportunity for the creditors to get a piece of your estate. So if someone especially has an illness before they pass away, we know how expensive it becomes to get medical care in this country. So if you pass away, have your estate go through a probate, there might be a huge medical bill that takes a lot of your estate before your family gets it. So we try to avoid having probate. We do the living trust, the beneficiary designations go directly to the person, whether it's life insurance or the 401k and things like that. So if we have real estate, we try to make the property what we call right of survivorship. So if you have two people that own property, like a husband and wife, if one of them passes, the property automatically goes to the other one without going through probate. So you definitely want to make sure, if possible, to avoid probate. And then the last one is just kind of the nightmare tell you here, that my current spouse gets my assets instead of my former spouse. Many times people have these beneficiary designations, say they had an IRA before they got married. They were married before, now this is their second marriage. They had their first spouse on the IRA. They get married to the new spouse, they don't update the paperwork. They pass away, that first spouse that they were married to can get $500,000, and the new spouse gets nothing because they didn't update the paperwork. So we want to avoid that kind of stuff. And the thing I want to point out here, if you go through each one of these, this does not have to do with anybody who's wealthy. Okay, anybody can have each and every one of these issues. So I want to drive home tonight that estate planning is for everyone. Okay, especially on the health side and paying your bills. Everyone needs to do that. I don't care if you have $1 million or you got 10,000. We all have bills to pay, expenses, things we need to do day to day. Certainly speaking with doctors and anyone with minor children, that is definitely a situation you need to take care of with a will. Okay, I'm glad you asked that question because you actually have multiple things in there. I'm going to address them piece by piece. I'm going to start with the password online. A lot of times, because these things are digital, the power of attorney in the 21st century doesn't come into play as much, right? So someone might have their bills on auto draft, right? So no one actually needs to actually do anything for a bill to be paid, especially if they have their benefits, directly deposited into the bank account, and then bills are being auto drafted, right? So the practical part of that person's need for a power of attorney to do financial matters may not exist. But there are other times when someone might pay by check, or the old-fashioned way, right? They mail their bills or pay in person or whatever. So you need to have power of attorney. Now, what you're referring to with a bank, we in Georgia have what we call a uniform power of attorney form that started in 2017. The reason why it started is attorneys would draft their own forms. So if you can imagine, every single attorney had their different form of how they arranged their power of attorney. The banks were very confused when they read it about what was being given, right? Because we didn't follow the same formats. So now in 2017, the state legislature of Georgia said, look, we're going to make this uniform form so that everyone knows when this box is checked, exactly what powers are given. If this is filled out, exactly what powers are given. So since 2017, it's been a little easier for banks in terms of accepting power of attorney. And if you use the uniform form, a bank has to accept it, or if they don't, you can take them to court and force them to accept it. So that's something that's new since 2017. Now, to your question of the bank having their own power of attorney form, even with the power of attorney form that's uniform, if someone comes to me and I give them a power of attorney form, that's a very generic document. Many times, say someone comes to my office in September 2020, we do all the paperwork. More likely than not, they put it in a book and they put it on the shelf or in safe deposit box. If they're fine in their health for many years, say they're fine until 2030. Now in 2030 they have a problem, someone goes to the book that's 10 years old and pulls out this power of attorney form. So if they go to the bank, many times the bank is very concerned because they're saying, this form is 10 years old. How do I know this is still a good form? How do I know the person still wants this person who's showing up in front of me to still have this power? Okay, so sometimes it's just the sheer age of the document. So to counteract that, they said, we feel much better if people come in to our branch in front of our managers and fill out our own bank power of attorney form for that account. So if you do that, that is just something that gives them an extra level of ease. So it's just a practical thing that they want, because if someone comes later in 2030 and they say, hey, I'm here with the power of attorney, and they can look back in their paperwork and say, okay, Keith brought him in 10 years ago and signed a power of attorney over, so we feel comfortable that it's still okay in 2030 to give him the power. So that's where that comes from, with the bank asking for their own. It's not a requirement that you sign it, but for practical purposes, they'll give you a hard time if you don't.
Okay, thank you.
You're welcome. Any other questions on that piece? No? Okay. So now we're going to start with our little scenarios. And if anyone who's seen my presentations before, they know I have a very unnatural love of the Brady Bunch. This is my favorite stuff from when I was a child. So I always like to use them in my examples. So we're going to start with a single mom. We're going to go different stages in life. And I want to show you, as you go through each stage, how these documents work and when they may need to be updated, even if you've done them already. So stage one, we're in single mom stage. So we have Carol Martin. She's a widow, and she's also a single mom. She has 3 lovely daughters, Marsha on the top there, Jan, and Cynthia, who goes by Cindy. So these are her daughters. They're all right now, all minors. By minors, I mean under the age of 18, okay? So let's go through our documents. What does Carol as a single mom need with minor children? Power of attorney. She needs to make sure that someone, all her children are minors, so there's things that they probably cannot do for themselves. In addition, because she's a widow and a single mom, she may need to make sure her power of attorney is filled out so that maybe other family members, whether parents or siblings, can do that. So she has to think through the roles. Sometimes people don't have family members to do that. They need to search out friends. So it's very important for someone who's single with children to make sure their power of attorneys are complete. Advance directive, certainly if anything happens to her, she wants to make sure that she has that document completed. None of her children can serve, they're minors, so she's going to have either other family members or friends do that. The beneficiary designations, if she's working and has benefits, say like a 401k through the job, she wants to certainly make sure that's listed with her children. And then the life insurance, hopefully she has some of that in case something happens to her. So all that would pass directly to the children, but because they are minors, if she leaves things to the children directly, they're actually not able to receive it. So if someone has minor children, we actually talk to them a lot of times about forming a trust. So you see the next item is a trust. Many times we'll say, maybe you want to form a trust and change your beneficiary designation from your children. So if she listed Marsha, Jan, and Cynthia on her 401k, we would say, no, you probably want to make it payable to your revocable living trust. The revocable living trust, in the terms of the revocable living trust, would say, leave this property to my children, but because it's not being left to the children directly, it can pass. A life insurance will not pay proceeds to a minor. So these things she has to think about being a single mom. And then, of course, last will and testament, if something happens to her, she passes away. As I mentioned, this is the only place that she's going to be able to appoint a guardian and conservator for her children. So if she does not do that, she leaves it open to the court's interpretation. So they might find a parent, they might find a sibling. If they don't find anyone, it might be, foster care. So it's critical for Carol at this stage, because she's made a widow in particular, so there's not another parent a natural parent that's going to take over. She has to have a will, okay? Any questions on that? This is most attorneys will do this, as we call it, a package. So you can usually have a will package, which would be a will, power of attorney, advance directive, and beneficiary designation, or you can do a trust package, which would have the trust, a power of attorney, advance directives, beneficiary designations, and it also has a will, because if you create a trust, you have to, what we call fund the trust, put the actual property inside of it while you're alive. Many people don't get a chance to do that for every single thing they have. So you'll need a will that will do that, and we call it a pour over will. We think of it as pouring something. So it says, anything I didn't get a chance to put in the trust while I'm alive, pour it into the trust after I pass. But all attorneys that practice in this area full time, they'll offer all these documents together. The price will vary by attorney, so it's definitely not something you can just say this is what it's going to cost. So you'll need to check with the attorney that you're dealing with. But it will definitely be a package that they offer that for depending on what they offer their packages for. So stage 2. So Carol has now met the love of her life, Mike Brady. Mike has 3 sons, Greg, Peter, and Robert. He goes by Bobby. They get married. So now they call themselves the Brady Bunch. They're a blended family. Why do we call them blended? Because they're essentially 2 units that came together. Okay. For living purposes, day to day, they can treat themselves like one big unit and everyone's the same. But that's not how the law sees them. So we have to understand how the law treats relationships in blended families. Okay, so we're going to go through each scenario. I'm going to kind of walk through those same documents. So power of attorney. So remember the first example, if Carol did her power of attorney already, she probably appointed a parent or a sibling, and maybe Mike did as well if he was single. He may have had a parent or a sibling or a friend that was their power of attorney. So the question is, in Georgia, if you get married and someone has a power of attorney already before you got married, does that power of attorney get updated? The answer for Georgia is no. So if I have my mother or father as my power of attorney and I get married, my wife would not automatically be my power of attorney. So if I want to make her that, I have to execute a new document. Okay, so we have to be clear. That document, a power of attorney, does not get automatically updated when you get married. Okay. Advance directive. That is a form over your body, your healthcare decision making. If something happens to you, whether you get your life extended, different decisions. The question is now, does that get changed, adjusted if you get married? The answer is yes. It is not the same as a power of attorney because it has to do with the care of your person. The Georgia legislature thinks that that has to rest with the spouse first. So if I had my mother or father as my advance directive agent and I get married, my wife would automatically become my agent. That's by operation of law. I do not have to do anything with that paper. If I do not want my wife as my agent once I get married, I would have to execute a new advance directive and reappoint my parent or spouse, sibling, or whoever else that's not my spouse. So I just want to be clear. Power of attorney does not adjust when you get married, but an advance directive does adjust to put your spouse as agent when you get married. So we need to understand that. Beneficiary designations. Remember, these are the big items. These are your 401k, your IRA, your life insurance. This is really where most people have their money. These items may or may not adjust when you get married. Retirement plans, it depends what type you're talking about. 401k, has anyone heard the term ERISA in terms of their work, their benefits? ERISA is a government act that basically was trying to give fairness to workers in terms of retirement plans against the owners. A lot of times would make plans that were unbalanced. So ERISA has certain provisions in it, and one of the provisions is if you have an ERISA plan and you get married, your spouse automatically becomes your primary beneficiary, And to get them out of that position, you cannot remove them. They have to actually disclaim themselves out of that interest. So they have to give it up. How does that matter? So, for example, if Carol and Mike get together, if each of them were working and had 401ks at work, when they got married, their plans would say, okay, you now are married. Mike, Carol is your primary beneficiary. Carol, Mike is your primary beneficiary. If they don't want to go with that, they need to change that, and each of them would have to disclaim their interest. Okay. Now, an IRA is not the same. IRA is not an ERISA. So if I'm working, I don't know if many of you have left the job, and when you quit the job, you take your 401k and transfer it out of the company's 401k into an IRA. Has anyone ever done that? Maybe. Well, if you leave your job, many times you'll have to transfer the funds and put it into an IRA. The IRA, individual retirement account, since it's not ERISA, it does not get automatically updated. So if Mike was married previously to, say, Jane, and had Jane as his primary beneficiary on his IRA, Mike gets married to Carol, doesn't update his paperwork, that IRA still is showing Jane's name on it. Jane will get the money when he passes away if he never updates his paperwork. So we have to make sure married is one of those events we call life events. So when that life event happens, you need to check all of these documents to make sure they're in sync with your current status in life. Life insurance is absolutely something that will not update when you get married. So if you have a spouse that you want to pay those funds to, or if you're a spouse thinking that you want to make sure you get your spouse's life insurance, you need to make sure you check that paperwork and it's changed. Because a lot of times, especially if they were single, they might have placed their children as the primary beneficiaries. And if they pass away, those funds, like I said, will be paid to the children. Even if they're minors, it'll have to go through a special account, but it won't go to you as a spouse. So you have to make sure to check these documents. If someone had a revocable living trust, that does not get updated. So if each of them have their own revocable living trust that they created because they're trying to avoid probate, and they had real estate in there, that does not get updated to their new spouse. So many times you need to sit down with your spouse with an attorney and start thinking, what assets do you want to share, or what assets do you want to keep individually? Because a revocable living trust will not update. Okay. Now, the will. This is very important to understand. A will be partially revoked when you get married, not fully revoked. Okay. So if I made a will that said, say Carol was single, and Carol said, I leave all of my assets, my estate, to my children, her 3 daughters. If she never got married and passed away, obviously the children would get 100%, correct? Okay. Once she gets married, Mike, then, assuming she made that first will without knowing she'd ever married Mike, and had no language in here saying, I know I'm making this will even though I'm getting married to Mike. Most people don't do that. So when you make a will, the presumption is you didn't make that will knowing you're going to get married again. The state says we don't want the spouse to be left out. So we definitely want to give the spouse something. And what we do with that situation, has anyone ever heard the term intestate? Intestate is when someone dies without a will. And you might have heard the phrase, if you don't have a plan, the government has one for you. Has anyone ever heard that statement? So if you pass away and you don't have a will, there's a statute that says, if you have a spouse and children, this is how much gets distributed. A spouse gets a minimum of 1/3. If there's only a spouse and you had no children, the spouse gets 100%. If there's a spouse and 1 child, they get 50-50. So it depends on how they break it out. So in this situation with Carol, she would have her will partially revoked right now and needs to have that will updated. So she needs to, and Mike will also the same way. He has his sons listed, he needs to have updated. So every single document that someone has when they get married will need to be updated to make sure it's in sync with their new marital status. Again, just want to go back here. None of this has anything to do with how much money you have. Okay, these are just things that need to be done because your status in life has changed. That power of attorney has, you need to do that. Advance directive, healthcare decisions. These things all need to be done, and you don't have to be a millionaire to need to do these things. And of course, with the last will and testament, because she is now married. Remember, last will and testament, you make a provision for minor children. So when she was single mom, she might have had, say she had her sibling, say she had a sister, that she said, when I pass away, I want my sister to be guardian of my children. Well, now that she's married to Mike, she may not want her sister to be guardian of her children anymore. She may want Mike to be guardian of the children now that they're a family. So she needs to update the last will and testament, and Mike also. Mike might have had a sibling or a parent on his will to take care of my sons after I pass. He may want Carol to serve that role. So last wills and testaments are the things, especially if minor children, that need to be updated because you want to usually change who the guardian of your children will be. All right, now we're going to move to the next stage. Unfortunately, Carol developed terminal illness and she passed away. So we want to examine what happens in this situation. So we're going to go through this scenario. If Carol passed away and she did not have a will, what happens? Remember I said the state will have a plan for her. And that plan is 1/3, she has 3 children. So it will say there's a spouse and 3 children. It will not divide it up 25%. It will not say 1/4 to each of them. It will say 1/3 to the spouse, Mike, and then the other 2/3 will be divided by the 3 children. That's the statutory scheme. It does not matter what Carol wanted. It does not matter if she didn't talk to any of the kids and that she was estranged from them. It's just a straight statutory distribution. So that's why you always want to have a will so you can control who gets what. Sometimes, a lot of times, people, because they're worried about price, they come in and say, you know what, I just want something simple. Just give me a simple will. Just leave everything to my spouse and then to my kids. And I usually tell them, you may not want to do that. Let's examine that. If you leave something to, if Carol leaves something to this Mike and then to the children, well, she left everything to Mike. If Mike keeps it, maybe he spends it, maybe he gets remarried and uses it for his next spouse, she disinherited her children. Because if she didn't have a will at all, remember I said the children would have gotten at least to split that 2/3. But once she made a simple will, leaving everything to Mike, then the state said, okay, she wants 100% to go to Mike and 0% to go to the kids. So you have to be very careful to think through when you have documents how things are going to pass. And remember also, if she did not have a will, that means she did not appoint minor children guardians. Because that's the only place to appoint minor children guardians is in a will. So if Carol passes away without a will, then she's leaving it entirely up to whatever county probate court to decide what to do with her children. So they may keep them all together. Hopefully if a family member steps up. But if there's not a family member that steps up, the court may split them up. So it's very critical to have a will, if nothing else, beside the property. I'm going to just say that over and over again. If you know anyone with minor children, or if you have minor children, you need to have a will in place just for that purpose. Stage 4, right? So we had the single mom stage, then the blended family stage. Now, we had the widower stage. So now Mike has gotten remarried. He's gotten over his loss, and now he's found some new love. He's feeling good again. And then after that, unexpectedly, he passes away. Okay, this is a lot of things that happen in life, right? Someone gets married, they meet someone new, they pass away, they remarry, they pass away. So things are in a lot of flux. As these things happen, the documents have to adjust. And we have to know what's going to happen to everything. So, power of attorney. When he got remarried to Ellen, what did we say happened? When you get married, your power of attorney doesn't adjust. So when he had his marriage to Carol, if he had Carol first, who knows who he had second? Maybe he had a sibling, a friend. When he got married to Ellen, that power of attorney didn't adjust the name Ellen. So when he got married, Ellen was not his power of attorney unless he redid his document. Power of attorneys end at death. So once Mike passed away, power of attorneys end the day of death. Okay? So if you have power of attorney over someone and they pass away on Wednesday, don't try to rush to the bank on Thursday morning to get cash out. Okay? That is not a good thing. Okay? Day of death, that power of attorney ends. Okay? Let's be clear. At that point, anything that person had is now technically, in the law's eyes, part of his or her estate. And that's when you have to go either to probate court and get those letters and file a petition to get the letters so you can get the ability to handle the person's affairs after death. Or if they did the revocable living trust, their assets would have been in the trust rather than on that person. So it doesn't matter if they actually died for the court's purpose. It just matters what the document says. If the document says, okay, when Keith passes away, he's named his older son, Antoine, as his successor trustee. The day I die, Antoine becomes successor trustee. No need to go to court. Okay? So we have to understand how these documents flow. So we don't know whether Mike had a revocable trust or not, but we know that the power of attorney ends that day. The advance directive, when he got married, what we say happened? The wife automatically Ellen became his agent by operation of law. So you get married, even though he had Carol listed on the paper, the second he got married, Ellen was his agent for advance directive purposes. So advance directive, that ends again at death for certain purposes. Obviously, we do not need to make decisions to extend life anymore because the person has passed away. But we do keep that document for body disposition. Sometimes people specifically indicate they want to be cremated or they want to be buried. If they say they want to donate bodily organs, if they say they want to donate the body themselves, maybe to a medical school, a medical program, or medical research, that can also be handled by the advance directive. So advance directive is life and death. So who makes that decision on his body? Not his children, Ellen, because Ellen became his agent when they got married. Okay, so if he didn't want that to happen and he wanted his children to make decisions on his body, he needed to execute a new document once he got married. Is everyone clear on that? Okay. Beneficiary designations. Again, if Mike left everything in Carol's name and never updated his stuff when he got married to Ellen, then life insurance would not be payable to Ellen. Carol's not alive, so what happens? Who did he name as the secondary beneficiary? More likely than not his children, because more likely than not he said, Carol Brady is my primary and my children are my secondary. So when he passed away, the life insurance people said, well, where's Carol? They said, well, she's passed away already. Okay, let's move to number 2. Who won't get paid? Ellen. So it's important as a spouse to make sure you are adamant to check paperwork with your new spouse and make sure, and it might be that you're okay with that going to the children, but make sure you have that discussion. And don't assume because you are in a role of a spouse in day-to-day life that the documents are going to find their way to send you the property. So 401k, that would update, like I said, that is a ERISA plan. That would automatically update. So if Mike was working and he had a big 401k, Ellen would be in luck that the law protected her and put her in that position. If he had a big IRA, if he had $1 million IRA and still had Carol's name on it and the kids as the backup, she would get nothing. So this is absolutely critical. I can't state this enough for you to check those beneficiary designations. Revocable living trust. If Mike had a revocable living trust, a revocable means he can update and amend it at any time. So he might have made it when Carol was his wife and said to Carol and my children. When he got married to Ellen, he had the option to update it where he put Ellen as the beneficiary if he wanted, or he could have left it as is and left the kids after Carol. We don't know that. But if he did nothing at all, the marriage will not adjust that document. So she would not get anything from that revocable trust. I met with someone today that was trying to put in 8 properties into a trust. So that's a whole lot of real estate. He had over $2 million of real estate. So if he got remarried to someone and they didn't make him adjust his revocable trust, that new spouse wouldn't get anything. So this is absolutely critical, okay? So let's get back to the last piece, a will. We're always trying to drive this home with the will, because we most likely people don't do the revocable trust. They usually keep things in their own name till they pass away. So we want to make sure we understand what happens. And I want to drive this home with blended families, so I want you to pay attention, okay? Now, Mike, remember, he had 3 kids, right? Or did he have 6 kids? Who were his kids? Greg, Peter, Bobby. Now, he had the girls, Marcia, Jan, and Cindy. Are those his children under the Georgia intestate statute? No, because they're not his birth children. They're not. The Georgia intestate succession statute goes by bloodline. So the only way you're going to be included as a child automatically is either be born to someone naturally or be adopted. When you're adopted, you're treated as blood and put into their bloodline by legal operation. So if they say, is there a spouse? Was that a question?
No.
Okay. If they say there's a spouse and children, when we're looking at this, we'll say, yes, there are children. There's a spouse and 3 children. There's Ellen, Greg, Peter, and Bobby. It is not Greg, Peter, Bobby, Marcia, Cindy, and Jan. Okay? So let's be clear. There are 3 kids and a spouse. If he had no will, the estate would be split evenly, but the spouse is always going to get at least 1/3. So if there were 2 children, it'll be even, be 1/3 for everybody. But there are 3 children. So it's 1/3 to Ellen, the other 3 children split the other 67%, right? That's how it would go if Mike did not have a will. So who's left out? The girls, right? So what happens if Mike still had his original will? Because remember, his original will said, I leave everything to my wife, Carol, and if she does not survive me, then to my children. Now, I'm going to assume that he went to an attorney, and he made, you can adjust that children legally if you make a will to include the stepchildren. So I'm going to assume he made a provision that said, my term children includes all 3 of my boys and the 3 girls from Carol. All right, so we're going to assume that his simple will covered all the children, okay? If he makes his simple will leave everything to Carol, the law says, well, when he made that will, he didn't know he was going to marry Ellen. So we're not going to punish Ellen and leave her out because he's left everything to Carol and didn't know that, years later he's going to meet Ellen. So the law steps in and it says, we are going to give her what she would have received if he didn't have a will at all. What is that? It goes back to that 1/3 again. So even if you're looking at the piece of paper and if you read it, you would think, okay, his 6 kids get 100% of his property. But the law says, I don't care what the paper says. Mike didn't know about Ellen when he made it. So we're going to give Ellen what she would get if he had no will at all, which is 1/3. And then the other 6 kids will split the other 67%. Now remember, if he had no, let's go back, if he had no will, it would have been the other 3 kids splitting the 67%, because the law says we only recognize blood. If he makes a will, he could add the other kids in, but they're still going to take care of Ellen for that 1/3. So now the 6 kids splitting the 67% rather than the 3. So things start to change a little bit for the kids, but at least now the girls are included, right? Because the first example, if he had no will, the girls were excluded altogether. So we're getting a little better. So at least all the kids are included. Well, let's go a little further, because Mike's trying to be a good guy. And we know what happens when you try to do good things. Sometimes things bite you in the butt. So if Mike says, okay, you know what? I'm married to this new woman. I need to do right by her. I'm going to go update my will so that Ellen, as my new spouse, gets everything if she survives me, and then my children if she doesn't. Seems like a very straightforward, upright, upstanding thing for a new husband to do for his new wife. Well, what happens? If he passes away, Ellen gets everything. Why? His will said, leave everything to Ellen, my new spouse. So Carol's children don't get anything. His own children don't get anything. So at least in the first example, if he had no will, at least his kids got something. In the second example, all the kids got something. If he tries to do the right thing with the new wife and leaves a new will, none of the kids get anything. So you have to make sure you meet with an attorney to make sure you understand how these things flow, because you can cause a tremendous amount of damage to the people that you love if you're not clear on whether your beneficiary designations are updated, if a will on how it flows, if it gets partially revoked. So all of these things are essential. And none of these things, to drive it home, are dependent on how much money you have. I don't care if Mike has $30,000. He wants it probably to go to his kids, but they're not going to get any piece of it. So we want to make sure we have these documents for our life, our power of attorney, our advance directive, or after death, the will, revocable trust, to make sure we know exactly how things are going to flow. Okay? So that was my examples.